Well, good afternoon, everyone. Just want to give folks another minute to complete login. But my name is Stephanie Otts. I'm the director of the National Sea Grant Law Center. I want to welcome everyone to our Shellfish Aquaculture webinar series. Today is our second webinar in the series, and we'll be discussing the evolving regulatory structure for shellfish aquaculture in several states. So thanks everyone for joining us today. On a bit of housekeeping, if you have any questions throughout the webinar, feel free to type your question into the chat box, and then our speakers can address them at the end of the presentation. Before I turn it over to our presenters today, I did want to briefly give a little bit of background for the webinar series and the project. So this arises out of a NOAA Sea Grant funded project, Overcoming Impediments to Shellfish Aquaculture, that the National Sea Grant Law Center and a team of collaborators received in 2017. And the overall objective of the project was to do legal research to identify challenges or barriers that to shellfish aquaculture on kind of the law and policy side. And we did this by developing 8 case studies from around the country. And the webinar series is sharing the results and highlighting the research that was done to prepare those case studies. Just wanted to highlight the members of the team, and so it does involve collaborations in Sea Grant throughout the country, including the Rhode Island Sea Grant Legal Program at Roger Williams School of Law, the Georgia Sea Grant Legal Program, which is based at the University of Georgia, the Carl Vinson Institute of Government in partnership with Georgia Sea Grant, California Sea Grant, and the William and Mary Law School, which has a partnership with Virginia Sea Grant, and then the National Sea Grant Law Center.
Wow.
If you're interested in more about the overall project and to get copies of our case studies and the final report, we do have a project website. You can get to it by Googling the National Sea Grant Law Center and navigating to projects from our homepage, or you can follow the link at the bottom of this slide. And we are recording the webinar, and we will make it available on our website for viewing afterwards if you have colleagues that are not able to join us today but might be interested. And then just to briefly touch on our upcoming webinar, interested, and we'll come back to this. We do have 3 webinars happening in August. You can register at the same website where you registered for today's webinars.
Crazy. Yeah.
And with that, I want to turn it over to our first presenter, Shauna Jones.
So my name is Shauna Jones, and I direct the Georgia Sea Grant Law Program, and we're here today to talk about some of the exciting things that are happening with Georgia oysters. So again, Stephanie did a great job of introducing us, but I am public service faculty at the University of Georgia. And with me is Chris Bertrand. He'll be speaking later, and he's a second-year law student at the University of Georgia School of Law, and he is a Georgia Sea Grant Law Fellow. So a little bit of background about oysters and the Georgia coast. You know, the Georgia coast is only 100 miles long, but we have 1/3 of the East Coast salt marshes. And our marshes stretch in a band 4 to 6 miles wide. And so our DNR estimates that the state has more than 378,000 acres of salt marsh. So while we are perhaps small in length, if you drive on I-95, we are, you know, a little bit more mighty than it might first appear, and it's a tremendous resource. And something else to know about Georgia that is distinctive and beautiful is that we have a large, what they call a large tidal amplitude. And this means that twice a day, the tides along the coast rise and fall 6 to 8 feet. And this allows some unique ecosystems to exist, such as these salt marshes that you see here. And it also results, and we'll talk about this a little bit more, in oysters that grow in clumps. And it's a very productive ecosystem. This tidal amplitude provides a lot of food and nourishment to oysters, so they grow really great. But they grow like you see in the bottom picture, in clumps. And it's brittle, and they're difficult to harvest for on the half shell. Another thing y'all may not know, if you're not from Georgia, is that Georgia has a tremendous history of oystering. And until the 1930s, we actually led the country with 13 canneries. And that has changed, obviously. Over-harvesting and market changes led to a decline. And while the clumped oysters are wonderful to steam and they're great to eat and they're great for canning, but tastes have changed. People don't eat as many canned oysters as they used to. They eat them on the half shell. And this leads us to where we're going. So clustered oysters, which is what we have naturally in Georgia, are perfect for backyard roast. They grow in clumps. They have brittle, sharp, elongated edges, and they're relatively inexpensive to buy. And this data may be a little old, but this is from our Coastal Resources Division. The cost is estimated $35 to $60 a bushel. Single oysters, which is actually what most people think of oysters when they eat them, are attractive for fine dining. They grow separately as individuals. They have smoother edges, and they were worth more, maybe $200 a bushel. They're expensive comparatively. Only aquaculture allows for these more lucrative half shells. There's a little data there. And so before we kind of move into where we're going to get to those half shells in Georgia, I want to just give an overview of our general regulatory framework. And so this is probably pretty straight ahead in most places, but first you have to be an approved shellfish water under the National Shellfish Sanitation Program. You have to have a right to harvest those oysters. You have to qualify for a master harvester permit. And then you have to have a series of license and certificates, and we'll talk about all of these. So an approved shellfish water, this is just, y'all are probably very familiar with this as all the states are under the National Shellfish Sanitation Program, but this is for public health reasons. And in our state, the Georgia Coastal Resources Division, which is part of the DNR, verifies whether these particular waters are approved. And they do things like monitor fecal coliform levels for at least 30 months. The second thing that in order to harvest oysters in Georgia, you have to have a right to the oysters in the beds. And these are some overviews, and we'll show a picture because sometimes pictures are easier to understand. But in Georgia, Georgia's tidewater beds are either state or private property. The person must have the right to the oysters in the waterbeds, and they have to validate this right. And if the person owns land adjacent, everybody may want to mute their phones if you haven't. That might help with some of the feedback. But back to this. If a person owns land adjacent to a private or state waterbed, he or she holds the right to harvest oysters from that bed. And if you don't own the land, you must enter into a lease agreement. So let's look at a picture that we put together as part of this project to describe these property rights, because having a right in some ways is very related. It's a property right related to harvesting oysters. So if you look at here, this is where the oysters grow naturally in Georgia. They grow in what is called the foreshore or the intertidal areas, and this is between the mean high water mark and the mean low water mark. And there's various laws in Georgia that describe who owns this. And what's interesting is that this picture looks complicated because having rights does not always correspond with who owns it. So the state can own, if you will, the foreshore, and it can also, if there's a stream, private property owners actually own the foreshore. But both for streams and both for tidewater areas, the adjacent owner who would live in the uplands has a right to those oysters. So what this doesn't mean this person owns this property. What it means that this adjacent landowner has rights to harvest these oysters. And this person could enter an agreement with someone else, a lease to harvest these oysters. This area, because it's beyond the mean low water mark, it's not, the tides move back and forth, but it's never exposed to air. This is the water bottom. The water bottoms are owned by the state. Now in Georgia, and this may be true in other eastern states, there's what's known as King's Grants, which if you can trace your title all the way back to when the king was issuing grants before Georgia became a state, you may actually have ownership over these water bottoms. But for simplicity's sake, generally the state has ownership of the water bottoms. So with that, those are related more to the property rights and who gets the right to harvest these oysters. But the same terms when it comes to permitting, which we'll talk about soon, are for these same areas. So traditionally in Georgia, the only area where folks harvested was the intertidal area, that foreshore area. The new law, which was passed this year, relates to the subtidal area, that area where the state has complete ownership for the most part, where the waters are navigable and where people want to put cages. So that's the background and the overview. I'm going to talk a little bit more, but then pass it on to Chris. But we had some very important changes. House Bill 501, it amends the seafood article with the title 27, which is game and fish. And these are a lot of words. This is the legislative intent, but it's really important to take a look at the legislative intent because it very much informs how the law is structured and how it will be implemented. So some words I'd like to point out, or just to emphasize, is that when the legislature passed this, they're very interested in increased seafood production. They're very interested in economic development. Very interested in increased ecological benefits. Oysters are great filter feeders. This is good for habitat. But also in this legislative intent, you'll notice are two mentions of public health. So the General Assembly wants balance with public health. And they also are interested in balancing this, making sure it's compatible with the environment as well as other public uses, navigation, fishing, swimming, and recreation. And so in this legislative intent, we have moved from the foreshore, from the intertidal areas, we are out in the water. And because of that, the legislature is charging the CRD when they implement this to consider all of these factors. And just to bring the point home again, later in the statute, when the DNR board is promulgating rules and regulations, the new legislation reiterates that public health is the primary consideration. So I'm going to turn over to Chris, our Georgia Sea Grant Law Fellow, who will talk about some of the major changes in the new law.
Thank you, Shauna. And as Shauna mentioned, I'm a UGA law student, and I've been studying the changes within oyster law. And so I'm going to outline some of the changes that have recently happened with the advent of the new 2019 law. So first of all, I just wanted to point out some of the biggest changes that have come with the new law, and that is now we have subtidal leasing. So that's the area Shauna already described that is in the water bottoms, and it's below where the tide goes in and out, and that area is always covered with water. And then also one of the other big changes is now we have mariculture, otherwise known as oyster farming in our case. So now the 2019 law has authorized oyster farming. So right here in this slide, I laid out a quick roadmap for the different areas of law that I'll be covering in the presentation. So first, I'm going to go and discuss how does one get a lease. So under the old law, how did that occur? And then now under the new law, how does one get a lease? And then once you have a lease, so you have the rights to harvest that area, then you still need to get your permission from the state, and that's when you need to get your permits. And so after I talk about leases, then I'm going to go in to discuss permits. After that, I'm going to start talking about harvest restrictions. So there are restricted harvest times when the state wants to make sure that the waters are safe and so there are no oyster illnesses. The new statute has put in some exemptions for basically there's proper regulations. They can ensure that the waters are safe to harvest oysters during all times. But I'm going to go into this later so we can put that off for now. And then lastly, towards the end of the presentation, I'm going to talk about hatcheries. So oyster farmers need to get their seed, they need to get their baby oysters. And so in order to do that, they got to buy from a hatchery. And that's where they're going to get their steady supply of oyster seed. So first of all, how to get a lease. So under the old law, you could only get a lease in the intertidal. And as Shauna mentioned, the intertidal is the area where the tides go in and out from the high tide mark to the low tide mark. And so under the old law, first, if one was interested in getting a lease for intertidal, they would first apply and indicate an area they thought was good. Then the CRD, the Coastal Resources Division, would decide if that area was suitable and if it was in the best interests of the state to give out an oyster lease there. If they decided that was a good area and that area was suitable, then they would open up competitive bidding. So they'd open up a competitive bidding process, and individuals interested in leasing there would submit bids to the CRD. And then after that, the CRD would choose the bidder it considered the most advantageous for the state. And in cases where two bidders were considered to be equally advantageous, then the CRD would prefer a Georgia resident over a non-Georgia resident. So that was the old law. Now in 2019, we have two paths for two different leases, basically. So we still have the intertidal lease, and that's changed a little bit, but now we also have the subtidal lease. So for the intertidal lease, where the tides are going, now instead of a person applying, the statute says that CRD, Coastal Resources Division, will give notice when it finds an area that's suitable for an oyster lease. And that notice is probably going to look something like 2 weeks notice in a county newspaper of the county where the lease will be located. After that, individuals can apply, and there's still the competitive bidding process just like before. The new statute does say that there must be a $15 minimum per acre cost, so the bidding starts at $15. And then CRD will announce who they think is the most advantageous. But now there is just overt preference for state residents. So in the prior law, there was preference for state residents if the two bidders were equal. But now we just prefer state residents overall. And CRD can also look at past compliance to the oyster law, to these oyster statutes, when deciding if someone is the most advantageous. So they can look at someone's history. If they've oystered before, they can look at their history of compliance. And so next we have a new form of leasing from the 2019 law, the subtidal leasing. So CRD can offer up subtidal leases, but they must consider navigation, fishing, swimming, and other recreation. And so once they consider these, then they can decide if this area in the subtidal is suitable for an oyster lease. If they decide it is suitable, then they will use a lottery system to hand out these oyster leases. And we don't know a lot about what the lottery system looks like right now in the statute, but that will likely be described later on through the processes of the CRD. So what we do know, though, is that the lottery system will have preferences for certified firms, leaseholders, and state residents. And also, there will be a $50 minimum per acre charge. So next, I wanted to talk a little bit about distributing public resources. So as you may all know, there are limited public resources. And when it comes to commercial use, not everyone is going to be able to use them. And in this case, not everyone's going to be able to get an oyster lease because there's just not enough area. So this is kind of like commercial fishing and crabbing in the sense that there's limited public resources and we have to have some sort of process to select people over others in order to give out these public resources. And that's when these sort of methods that we've been discussing for giving out oyster leases come into play. So some people do first come, first serve, some states do, or like we've done and other states do, competitive bidding processes or lottery processes in order to figure out who will get these public resources, who is going to get the oyster lease. And so as part of my research, I looked at a few bordering states to see how they distributed their public resources and specifically how they distribute oyster leases. So first I looked at Florida and how Florida gives out their oyster leases. And so if you want to seek an oyster lease within Florida, you are going to do so through two avenues. One, you could apply for an aquaculture use zone, or you could propose a new site. So what an aquaculture use zone is, if 10 or more people are applying for a similar area, they all think, 10 people think this is a great area to oyster. And they're all applying for this area and they're saying, we need to oyster here. And that all is within 6 months to one water body to a similar area. Then the equivalent of the CRD, which is the Department of Agriculture in Florida, they will authorize that area as a good area to oyster, to farm, or to harvest all at the same time. And when the Department of Agriculture in Florida decides that this area is going to be an aquaculture use zone, they will make a recommendation to the board of the governor and to decide if they're going to give out these leases through a competitive bidding offer or through a lottery system or through some sort of first come, first serve process. And then also, as I mentioned before, you could propose your own site. So if you're not within an aquaculture use zone, or if there's not an aquaculture use zone already implemented where you want to oyster, you can suggest a new site, but that is a much longer process. And you have to get a lot of different departments to authorize you to be able to oyster there and to get a lease there. So next, I looked at South Carolina and how they procure leases there. Something interesting to know about South Carolina is that in order to get an oyster lease in South Carolina, you have to be a South Carolina resident. So if you're not a resident of South Carolina, you just can't get an oyster lease. It's not preference, you have to be a resident. It's a qualifier. So once you're a South Carolina resident, then you can propose an area, or you can choose an already selected and already approved area for oyster lease. So if you choose an area that's already been approved, then a Shellfish permit committee decides if you, the candidate, will get a lease there. And if two otherwise equal candidates both propose for a lease, then a lottery system is done. So they basically have a lottery system for ties in South Carolina for oyster leases. So Georgia introduced a new system. We have the lottery system now statutorily for subtitle areas. And this is actually not too uncommon because a lot of other states use the lottery as well. We already mentioned South Carolina, but other states like New Jersey, Delaware, Florida has the option to, Louisiana used to, and New Hampshire use various forms of the lottery. So I looked briefly at some of these other states' lottery systems to see how they worked. So New Jersey, Delaware, Florida, and Louisiana, when they had a lottery, they did something that I like to call a lottery for draft order. So how this lottery system worked would be everyone who's interested in an oyster lease would put their little ticket in a hat, and then the equivalent of the CRD would draw out the individual tickets, and the first person drawn out of the hat, they would be the first person to work with the CRD in order to pick a lease. So if I put my ticket in the hat and I was drawn out first, and I'm the first one working with the CRD, and I get to pick my lease area first. The second person then gets to work with CRD second, and they get to pick what area they want to lease second. And then we already talked about South Carolina system. So if there's two otherwise equal, or there's two people that South Carolina is considering, and they seem about tied for qualifications. Then there's a lottery. New Hampshire, on the other hand, does a somewhat similar lottery for ties like South Carolina, but with New Hampshire, they do a first come, first serve method. So everyone submits their applications, and if 2 people submit an application on the same day, you got kind of a tie. But then if 2 people submit the application on the same day, then New Hampshire will do a lottery. So that brings us to our next section, permits. So with the new law, we have a new permit. We have a couple new permits. And I'm going to talk first about the commercial fishing license, and then I'll go into the mariculture permit and the cage permits. So the commercial fishing license with the Shellfish endorsement is a new permit requirement, and that goes along with your basic harvesting permit. So you have to have a permit to harvest the oysters, either as a master harvester or as an employer, a harvester. But you also are going to have to now, under the new law, get a commercial fishing license with the Shellfish endorsement. And so, as I mentioned earlier, one of the really big things about the 2019 law is that we can now conduct mariculture. We can oyster farm now. Nonetheless, in order to oyster farm, you first have to get a permit. So to get a mariculture permit to conduct mariculture and oyster farm, an individual needs to have an operational plan. They have to list or write out the species that they want to farm. They have to include the types of gear they're going to use. They must include the amounts, locations, sources, and types of shellfish seed, including the genetic strains that they will be using. They need a storm mitigation plan. They need a wildlife mitigation plan. And then they also need any other information that might be required by the department, in this case, the Coastal Resources Division. Also, it's important to mention that in order to conduct mariculture in the subtitle, so to oyster farm in the area past the low tide where it's always covered in water, you have to have a $20,000 performance bond. And then our last new permit is the cage permit. So we don't know too much about what the cage permits are going to look like. The CRD will likely later decide the amount one can get for release and the sizes of these cages. But what we do know right now is that when you want to get a cage permit to have cages on your area to oyster, you need to apply for these permits at the same time that you apply for your mariculture permit. So this is happening at the same time. When you get your mariculture permit, you're getting your cage permit. These permits are given out at a 25 cage increment per permit, and there'll be $1 per cage.
Can I just add something, Chris?
Yeah, for sure.
As I think I understand it, it's not a permit for every 25 cages, but the permit will encompass, they only want to see in the permit 25, 50, 100, like it's one permit with those things.
Yeah,
yeah,
good specification.
Yeah, just to be clear.
And then that next that brings us to the restricted harvest times. So restricted harvest times are put into place in order to protect consumers because we don't want oysters to have illnesses. Nonetheless, there are known and approved methods to make summertime harvest safe, and other states do it within subtidal waters. And summertime harvest specifically because that's when the waters are getting warmer, so there's higher chances of illness. But as I mentioned, there are already approved methods in place that other states do that will make summertime harvest absolutely safe as long as the proper regulations are followed. So with this new law, there is a possibility for an exemption from the summertime harvest restrictions. And here's just some of the language we just threw out here that talks about what you have to do in order to get an exemption. So in order to get an exemption, basically, you're going to have a closed season operational plan. They want to make sure you're farming in a safe way during the restricted harvest season. You also have to have a list of the trained harvesters you're using and the receiving certified firm. So who's buying your oysters and the people you're using to pick them to make sure you're doing everything proper in order to be safe. Also, there is consideration of past compliance with oyster statutes when considering to give out a master harvest exemption for the restricted harvest times. And that brings us to hatcheries, the last part about the new law that we'll be talking about today. So hatcheries, oyster farmers need a consistent and steady supply of seed that is of good quality in order to plant into oyster farm. So where are you going to get this seed? Where are we going to get these baby oysters? We're going to get them from a hatchery. And so what the new law has put into place is that seed must be bought from a CRD-approved hatchery. So that's whether it's an in-state hatchery or an out-of-state hatchery. You could buy it from there, but you have to get CRD approval before you purchase that seed and put it into Georgia waters. And then lastly, I briefly looked and touched on what were Florida's and South Carolina's provisions in regards to restricted harvest times and hatcheries. So just briefly with Florida, they don't actually have restricted seasons for harvest, but you still have to comply with pretty regulated health standards. And on the right of this slide is a chart of all their health standards and basically the regulations for shellfish harvesting. So even though they don't have a restricted harvest time, they have very stringent regulations to make sure that everyone's safe. And then in regards to seed approval for hatcheries in Florida, like in Georgia, you need to get permission before you obtain seed to put into Florida waters from a hatchery. And then South Carolina. So in South Carolina, just like in Georgia, there's a restricted harvest season for those warm water months, but there are exemptions. So if someone is putting in time and they're doing everything right in a safe way, then they can get an exemption from the warm water harvest, and they can harvest within the warm water restricted times. And then lastly, as in South Carolina, or in South Carolina, as in Florida, as in Georgia, you also need to get approval for your hatcheries before you purchase your seed. And so that wraps up and ends all of the research that I recently conducted on the new changes in the oyster law and a couple comparisons to our neighboring states. So I'm going to pass it over to Shauna, who's going to make some conclusions for us and finish off the presentation.
Thank you. So great job, Chris.
Thanks.
Really good work. So, you know, we're at the beginning in Georgia, and it's very exciting. There's a lot to do. There's a lot of people really thinking about this. And some of the details, frankly, are to come. And, you know, when I started this project, thanks to funding from the National Sea Grant Law Center, you know, this legislation hadn't even been introduced. So we've come a long way, and it's going to be fun to watch. But some further details, I think folks are really looking to, there's an advisory panel that CRD is putting together that's going to be industry representatives and others of, you know, how will the lottery work? You know, that's not in the statutory language. It's just required. And then what does some of the permit requirements entail? I think is a big question for many. And certainly maybe the number of leases and things like that. So those are all kind of future details that folks will be watching for over the next year. And really the next steps in Georgia are to, I think, you know, see how the advisory panel works and the kind of decisions that they make and how they advise the DNR. And the DNR is charged with issuing these regulations and how will the policies and rulemaking play out. So 2019 and 2020 will be really interesting years for oyster aquaculture. So that's all that we have, Stephanie. Thank you all for listening, and I think Bryce is next.
Great. Thank you so much, Shauna and Chris. Yes, and so now we'll be transitioning to our second presentation, which is by Bryce. And so we'll just take us a minute to get our screens shared around.
Okay, thanks, Stephanie. It's giving me a message that says I can't share my screen while the other participants still sharing. So if whoever's sharing can unshare, awesome. Okay.
There you go.
There we go. Okay, good afternoon, everyone. As Stephanie said, I'm Bryce Burgwin. I had the honor of serving as a research associate and intern at the National Sea Grant Law Center this summer, and I'm a rising second-year student at Harvard Law School. And I'll be talking about the new state laws that have been enacted in the 2019 session, along with Georgia's. 4 other states have also enacted new legislation related to shellfish aquaculture. So those 4 states, which I'll be discussing, are Texas, Maryland, North Carolina, and Mississippi have all had pretty significant changes so far this year. And then at the end of my presentation, I'll conclude by taking a quick look at how just these 4 states handled the process of awarding their leases, whether they are awarded through lotteries or other methods, and whether the new legislation that was enacted addresses that or not, just for purposes of comparison with Georgia's new laws. Okay, so to start out with Texas, Texas had some pretty significant changes this year. So I'll kick off with that one. They implemented House Bill 1300, which amended portions of sections 11 and 75 of the Texas Parks and Wildlife Code, which really created a framework for cultivated oyster mariculture to get started in the state of Texas. So most of what they've enacted is brand new. The changes in Section 11 authorize the Texas Department of Fish and Wildlife to collect fees related to cultivated oyster mariculture. It also authorizes funds to be expended for cleanup of illegal or abandoned cultivated oyster mariculture equipment and related debris from public water, and adds cultivated oyster mariculture permit holders to the list of seafood producers from whom wholesale purchasers of seafood may buy. In Section 75, the legislation requires the Texas Parks and Wildlife Commission to adopt rules to establish a program governing cultivated oyster mariculture in Texas. So as I said, they're really starting from the ground up. The areas where the legislation requires rules is related to location and size of operations, taking, possession, transport, movement, and sale of cultivated or broodstock oysters, the marking of structures, establishing fees and conditions for the use of public resources, and any other matter that the Commission deems necessary to implement the program. No person in Texas may undertake cultivated oyster mariculture without a permit. And the legislation further authorizes the Commission to adopt rules to govern permit applications, application fees, criteria for approval, transfer, revocation, suspension of permits, etc. They also created a cultivated oyster mariculture cleanup sub-account within their game, fish, and water safety account. So 20% of the fees collected associated with cultivated oyster mariculture will be set aside for the cleanup of abandoned and illegal gear. Finally, the legislature established a criminal offense for violations of the statute. So it's a misdemeanor to violate the provisions included in House Bill 1300 in Texas. Moving on to Maryland. Maryland enacted House Bill 841, which repeals and reenacts with amendments Section 4 of the Code of Maryland. The legislation is significant because some states entirely prohibit shellfish aquaculture in areas with submerged aquatic vegetation, or the states are very reluctant to issue leases in those areas where there's vegetation growing on the bottom because of concerns about disruption of the ecosystem on the bottom. So Maryland has taken a different approach to balancing these conflicts in space between submerged aquatic vegetation and shellfish aquaculture. So they've decided that leaseholders may not place shellfish bags, nets, or structures on submerged aquatic vegetation without prior written approval from their Department of Natural Resources. So they do allow bottom leases and water column leases in areas where submerged aquatic vegetation is present. However, they also lay out considerations for approval. The legislation prohibits the Department of Natural Resources from authorizing harvest by dredging in areas where submerged aquatic vegetation is present, and also states that the department shall authorize for water column leases in at least 10% of an area where submerged aquatic vegetation is present, and shall authorize harvest by diving in areas where of any submerged land lease where submerged aquatic vegetation is present. So their considerations are in the direction of minimally disruptive methods. North Carolina enacted Senate Bill 648, which amends North Carolina statutes, section 113. North Carolina added a definition for shellfish aquaculture enterprise areas, which will include both bottom and water column leases. They also allow the Secretary of State to make the bottom available for new leases for 18-month periods, and to designate the bottom as a shellfish enterprise area, which was not the case with the previous legislation. It only related to the water column. The statute also requires removal of abandoned gear or any gear within 30 days of the termination of a lease, whether it's terminated by the state or runs its course after the end of the 18 months. Legislation also establishes hearing procedures for denied or modified lease applications. So for applicants who submitted leases that were denied or that the secretary made modifications and were not satisfied with those modifications, there's a appeals process that's laid out in the statute for North Carolina. Finally, the fourth state is Mississippi, which enacted House Bill 1269, amending Mississippi Code Section 49. And they took the step of establishing licensing fees for vessels engaged in off-bottom oyster aquaculture. So they laid out that it shall be $50 for in-state Mississippi registered vessels or boats and $100 for out-of-state vessels or boats. They also updated the requirement for captains of boats or vessels engaged in oyster aquaculture, including verbiage that requires the same $10 permit already required for on-bottom oyster aquaculture to also apply for off-bottom shellfish aquaculture. And just as a final, to tie back in to Chris's presentation earlier, just to compare the leasing methods, the bottom line up front is that all four of these states delegate the authority to decide about leasing methods to agencies. So none of the four states designate in their lease statutes the method that the agency must use to make the decision. So they don't require a lottery or any other specific method as Georgia does. Different states are more or less restrictive on how much freedom they grant their agencies in making their decision about how to do how to actually carry out the leasing. Texas doesn't specify the manner in which their leases must be awarded, and actually doesn't even specify that the water column, so non-bottom areas, need to be leased, only that they need a permit. Maryland does not specify in their statute how leases need to be awarded. It's just delegated to the Department of Natural Resources. North Carolina likewise delegates the authority to their Secretary of State and specifies some things that the Secretary must consider, but not the way in which the leases must be awarded. And that's the same for Mississippi. So that concludes my presentation, and I'll turn it back over to Stephanie. Thank you.
Great. Thank you so much, Bryce. And thank you to all of our speakers. Just sharing, just wanted to come back and mention that if you have questions, feel free to use the chat box to send them to me, and then I can convey them to the speakers. And while you're thinking, if you have any questions, just to remind everyone again that we do have 3 more webinars coming up in our series. On August 14th, will be Rhode Island Sea Grant Legal Program talking about some operational limitations. Their shellfish aquaculture farmers have encountered. On August 21st, it'll be about certification of shellfish growing waters in federal waters, and then we'll conclude at the end of August with discussion of case studies out of Virginia. And Shauna and Chris, we do have one question coming in. What types of gear are allowed under Georgia mariculture permits?
So that's actually, the gear is not, go ahead, Chris.
So if I believe with gear, you can use handheld gear, but if you want to use more extensive gear, you're going to have to get a permit. So yeah, if you need a permit except for a hand or handheld implement of gear. So that's just off the basic quick reading of the statute right now.
Yeah,
is the answer.
So that's going to be something that the details will come out with the advisory panel. I saw a question from Robert in that, yes, there's Georgia's pretty interesting. In like 1902, the General Assembly passed a law giving adjacent landowners rights to the intertidal beds adjacent to their property. So while you have those rights if you're an adjacent landowner, you have rights to harvest those oysters, you still need a permit. And so that's even true with King's Grant folks. I mean, it's always important to separate the right to harvest. That doesn't necessarily exempt you from any permitting requirements. Hope that answers. And I see a question from Jefferson about the duration of North Carolina water column leases. Do you have any recollection, Chris?
No.
I don't know. I don't have that.
No, I didn't study North Carolina very extensively, just briefly, and just glanced over it.
So
I think Jefferson might be referring to something from mine. This is Bryce.
Oh, okay.
So I don't have the answer to that question in front of me. The bottom leases were added as a new item, so they're in that new bill, but the water column leases actually aren't mentioned. So I'm not sure. We'll have to take a look at the new statute in place amongst the other previously existing information and take a look at that to find out.
And then there's a question from Ryan about, to clarify, in Georgia, are intertidal and subtidal waters public? So subtidal waters are definitely public. That's state-owned land unless there's a King's Grant, but for sure. What's complicated for ownership with respect to intertidal area in the foreshore is that if you're on a stream, that's actually private property. So that intertidal area is a stream, it's private property. If it's a tidewater under the law, it's actually state water bottoms. Hope that helps.
Great, thanks. And thanks to one of our participants, Christine Goebel, who sent a message to everybody that North Carolina did increase the possible duration of both water column and bottom leases, but not sure on the exact duration of that, but that was part of the new legislation program. Great. Well, again, thanks everyone so much for joining us. Thanks to our presenters. And I hope that you'll come back in a couple of weeks and join us for our next webinar. But if you have any questions following up from the webinar, feel free to reach out to Shauna or myself, and we can either get you connected to the right information or answer it ourselves. So thanks, everyone.
Thanks, all.
Thank you.